Hello everybody, nice to see you. Today is a beautiful day and I want you to join me on this quick walk around the neighborhood as I answer the question that I raised in this video, which is, if settlement discussions fail during the course of your medical malpractice case, can the information that is discussed during these settlement discussions be used against us at trial? You want to know the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's get right to it. The answer is no. That information cannot be used at trial against us. Now, why not? It's because settlement discussions are designed to try and get the parties to settle the case. Clearly, there's a dispute here, right? You believe that your doctor was careless and caused you significant harm and injury. The doctor disputes those allegations. All right, so there are clear issues to be decided by a jury when it goes to trial. But now, let's say each side recognizes that there are risks of going to trial. Each side recognizes that there's the potential to either lose the case or get a significant verdict, which means that the defense is going to lose the case. So what happens then? So now each side might be willing to go ahead and negotiate. And now certain things are discussed, such as different strategies by saying, hey, listen, if we go to trial, I'm going to tell you that your doctor is responsible because of A, B, and C. And now the defense turns around and they reveal their defense strategy, which is, hey, listen, I'm going to tell you that if we have to go to trial, our strategy basically is, listen, this guy did absolutely nothing wrong. He did everything correctly, and I have 3 experts that are going to come in to back up what he's going to say, and that what he did was absolutely appropriate. And of course, by the way, your client, the injured patient, contributed to this injury. So now they're revealing information to us. Basically, it's to try and gain positioning during the course of settlement discussions. And you know what? That can be very effective, especially when you're dealing with another attorney who you trust, when you're dealing with an attorney who understands the case and has a good basis of the medicine, and now understands exactly what the insurance company and his client feels about this particular case. Because if each side is willing to negotiate, now each side is in a good position to turn around and say, okay, let's see if we can try and resolve this case now without the need to have to go to trial. All right, so now let's say each side reveals their strategies about putting their best foot forward and trying to get each side to recognize, listen, if we go to trial, you're going to lose because of the following things. And the defense likewise turns around and says, listen, if we go to trial, you're going to lose because of these things. So now they tell us this information. But what happens in this scenario? What happens if we say, listen, I need $1 million to settle this case, and they come back with $750,000? And I say, listen, I can't settle the case. I need $1 million. I told you that. All right, fine. So now the case goes to trial. You might think that during these settlement discussions, now at trial, the defense could turn to the jury during opening arguments and say, ladies and gentlemen, can you believe this injured patient? They want $1 million to settle this case. We offered $750,000, $750,000. And now look at how greedy they are. And they're making us try this case. Can they do that? The answer is no, they cannot. They cannot do that at all. And if they were to try and reveal that information to the jury during the course of any part of the trial, that would be grounds for a mistrial. Why? Because that information is not to be disclosed. That information is not to be used to gain an advantage over any side or over any strategy or any position that we have, because we're doing this in an attempt to avoid the trial. So anything that we say during the course of settlement discussions is not to be used in front of a jury. Now, it can be used. This is important. Here's how it can be used. It can be used because we can now understand what the defense's strategy is. We can now understand how they're going to approach certain witnesses. We now understand exactly how they might cross-examine our expert. So it gives us a better view of what they are going to do. So it will help us properly prepare and strategize our own case. Likewise, the information that we give to them will help them do the same exact thing. So why do I share this quick information with you? I share it with you because sometimes people think, you know what? If settlement discussions break down, is the jury going to know about it? First of all, will they even learn that there are settlement discussions? The answer is no, they won't. They are never told about it. That's never discussed with them. And it's not part of what they're there to do. They are there to decide who is more likely right than wrong. So if we pick a jury and now we start taking testimony, the jury is there to evaluate whether whether they believe that we are more likely right than wrong. And if we are, then we're entitled to a verdict in our favor. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a great day.